These are important issues. So I'm going to ask the plaintiffs to go first with their motion for a temporary injunction.
May I remove my
Yes,
comment?
yes.
May I please record Terry Clayton of the Nashville Bar. Your Honor, this is a petition for injunctive relief, restraining order on actions that have been conducted by the Comptroller Treasurer. We are representing the citizens in this leadership of Mason, Tennessee. In that the town of Mason is in Tippecanoe County, Tennessee, in its northeast corner of this county, and that the city was incorporated back in 1915. In the state of Tennessee, cities are economic engine. They provide economic growth that is intentional, and when it occurs, they are really, financed by taxes that are paid by citizens in the area, and people that spend money in the area. And these expenditures of the city, provide for police, fire, streets, water, sewer, parks, and schools. And that these amenities attract businesses to the city. And that by investing in the city, it makes a place desirable to raise your families and also the business. And the taxpayers basically finance our infrastructure, and that and the states depend upon cities to collect revenue for. And what we're here for is to ensure that individuals who have been elected by the citizens of Mason continue to preside over its finances and make decisions regarding its future growth and development. The town of Mason is supposed to make up of 67% African Americans, and the other portion that being white and other individuals, because on the city council we have African American mayor, 4 alderpersons, and 1 that are black, 1 white female, 1 man from the Middle East. And the current mayor was elected in 2018, and that this is an election year, that he and the other alderpersons are up for election. So therefore, having been elected in 2018, he didn't really take office until January 2019. And when this administration was sworn in, they were given a gift of $870,653 that was owed to the water, sewage treatment, and the gas fund. And that, so immediately they had to start in arrears, trying to decide how to handle this debt of almost $1 million. So prior to these individuals taking office, Your Honor, the comptroller had been working with the leadership of Mason since 2011. The comptroller entered into an agreement in 2011. They allowed the city to propose a corrective plan, and that plan did not they didn't accomplish their objective in terms of completing the plan. So, what the comptroller then indicated that, hey, they still didn't make it. Let's give them another opportunity. So the city officials had an opportunity to propose another corrective plan. And that was in 2015. And the letter from the comptroller's office indicated that Mason, as virtue of his transfer of funds by 2013, that debt had increased. The water fund was increased, the debt was increased. And the reason why I think it's important, Your Honor, that we have to look back before we go forward. And we have to understand that the position that the leadership of Mason was in, the condition they was in 2018 when they took office. I'm sorry, 2019 when they took office.
And one of the difficulties too, as I understand it from reading about the history, is the audits weren't being provided or done contemporaneous with the fiscal years. So there was a general lack of understanding or appreciation of where that debt was and where the city was financially by everybody.
Yes.
Because the audits weren't being done timely.
It's just like someone taking over any bank account or any organization. You prefer to have those books audited before you take charge. This administration didn't have the opportunity to see those audits. They were behind. The audits were behind some 5 years when they took office. So the financial persons who were working for this administration, they were having to do double duty. They had to work on arrears and they had to work on current audits because they couldn't even get the current audits and the budget passed until all of the audits were done from the past. I mean, it's a situation where you have the sins of my father.
Yes, sir.
The sins of the persons who are leading this city are being having to be paid for by the current administration. And that, Your Honor, this administration is just really asking to be treated fairly. And we have to point out that in 2016, this is a matter of public record, the entire administration of Mason, Tennessee withdrew or resigned from office. And that will, so therefore, you know, in 2018, you had people were elected to just basically serve on a temporary basis until they were reelected or appointed in 2018.
So those were mid-term or mid-cycle resignations.
Yes, Your Honor. And in these instances, Your Honor, the comptroller gave prior administrations, those prior administrations have to be predominantly white, gave them an opportunity to participate in offering up the corrective plan. This administration has not been given an opportunity to offer up the corrective plan. They made some overtures, they've been paying back the debt. However, when the comptroller came to town on February 8th, he didn't meet with the mayor and the aldermen, and he did something that is quite unusual. That he came in, he sent out letters to all the members of the community, asked them to come to the meeting, in which he did not give the mayor and his aldermen an idea what the agenda was. So when he came in, he made some comments and ultimately put the mayor and his administration in a very vicarious situation when he said that they were not getting anything from the taxpayers, from the taxes that were being paid. So the mayor was kind of, you know, us was. And the comptroller went on to talk about the Blue Oval project that was coming, and that
That's the Ford plant?
the Ford plant. And we know that the comptroller was aware and negotiated about the Ford plant and Blue Oval and now what impact it would have on the community. Never sat down and had a conversation with Mr. Gooden about what was to be expected.
And am I correct in understanding that plant is outside the town border, but it's in the county within 5 miles or something?
Yes, it's adjacent county.
Oh, so it's not even in Tipton County?
It's not in Tipton County. It's adjacent.
Okay.
And Your Honor, as of 2016, the deficit had grown to $609,000 of water treatment plant, and gas fund that was $263,000. Now, this administration has been working to try to cure the debt and pay it off without much support from the Comptroller's office. And that they've been making payments anywhere from $3,000 to $6,000 a month. And
Takes a long time to pay off that much money at $2,000 to $3,000 a month.
oh yeah, but you have to put together a plan, Your Honor.
It has to be a plan that you can be successful with.
Right. And that, and all parties, I mean, we're aware that there was American Recovery Act, American Recovery money that was going to be available, and that money became available. What did this responsible administration do? They took and paid off $227,000 toward the outstanding debt. As of today, the outstanding debt is $258,000. And it is anticipated that the American Rescue Plan will be providing additional funds to the city later in the year. But however, with the city having spent all of the money to try to pay off this debt, they need to be in a position where they can manage the funds that are coming in without having a punitive amount of money that doesn't really equate with the amount of money they have coming in, whereas the Comptroller's office has right now $9,000 to be paid. However, if any time they miss this payment, I'm sure the Comptroller would have justification to come in and take over the city's finances. In that we were to allow clients to manage their own affairs, then they can pay this off over a period of time. So that's where we are, Your Honor.
And as I understand it, the entire treatment and the course of treatment is part of the complaint, but the particulars of the corrective action plan being insisted upon by the state that are the most concerning or create the immediate irreparable injury concerns are that the first dollars spent have to go against the payment plan of $9,564 a month, plus the approval of expenses over $100 other than non-payroll, other than payroll expenses. So that approval process and that inability to make discretionary determinations or to deal with emergency situations or just ongoing obligations, expenditures to keep the city doing business.
Yes.
And what is the status, I wasn't entirely clear on this, in terms of catching up on these prior audits?
They are in the process of catching up on those, Your Honor, and my clients have promised that they will, as soon as the auditors that lose money reports, return them to them, and my clients have asked the comptroller to take some time and call the auditor, let the auditor know, you need those audits right now, because they're being paid by the city.
I think maybe there's a draft fiscal year 2019-2020 audit that's been done. So once that is concluded, then they would only be behind on audit, and it sounds like, from thinking about the years correctly.
Yes, they'll be behind one audit.
Okay.
Hopefully that they can get their budget approved by the council.
Because the budget is being held up by the audit approval, is that right?
Yes, sir.
The state makes a couple of arguments in their responsive materials. They raise issues of sovereign immunity, and also they argue as to the constitutional claims that a township doesn't have the ability to bring equal protection issues. Could you address this with me, or I don't know if your co-counsel is going to address it?
My co-counsel will address them.
Because you all stood on your papers and were very thorough that you filed initially. The state has since filed a response, so you haven't had an opportunity to do that. So I am interested in those legal issues.
Yes, sir. And we'd also like to mention, Your Honor, that the city is owed about $140,000 from Tipping County. And we think that requires them to pay and reimburse the city for fire protection. And they have not received that. That could very well be utilized to pay down this debt. And the comptroller does have sway in deciding on enforcing this particular obligation. All right.
Thank you. That's a very helpful piece of information. Thank you.
May it please the court, Van Terry here for the town of Mason. And I think I was going to ask Your Honor, was there anything you wanted us to focus on? And I think I heard what you would like the folks to be on.
And I'm happy to hear whatever you want to address the court. This is an important opportunity to do that. But those two legal issues are obviously ones that I'm going to have to address in ruling on your motion.
Thank you, Your Honor. Also, Your Honor, if it pleases the court, we will reserve just a short rebuttal after the state has presented.
You will have the opportunity to have the last word since it's your motion and you have the burden of proof. So you can take the time that you need.
Thank you. And we did receive the state's briefing, and Your Honor, we are available and willing to brief as well. If Your Honor would want that as a post-hearing brief, we can get that to you by early next week, if that would assist Your Honor as well. We just wanted to say that because we are moving quickly, and the state has briefed, and we would probably want the opportunity to rebut in briefing as well, post-hearing.
And what I would say is that if you want the opportunity to brief, I'm happy for you to do that. I was cognizant of the concern about being heard as soon as possible, given that this corrective action plan went into effect Monday and your lawsuit was filed late Friday afternoon. So I wanted to move quickly enough to address those concerns, but to give the state the opportunity to be notified and to be able to respond. We can talk at the end of today about if the town would still have the opportunity to brief, and I would be pleased for y'all to take that opportunity, keeping in mind that the time is of the essence of these things, and I'm sure your clients are looking forward to the court ruling on the requested relief.
Thank you, Your Honor. On the equal protection claim, which Your Honor has identified, and obviously there is an important point for Your Honor to consider. We will rely on the authority of Tennessee Small School Systems versus McWhorter, Your Honor, which is a well-known case. It's found in 851 Southwest 2nd, 139, Tennessee, 1993. And essentially, Your Honor, that case provides that for equal protection claims, when officers of the state are acting outside of their scope, this court does have subject matter jurisdiction to address the concerns of the plaintiff. And so, Your Honor, that's, I think, good case law for us to rely upon. Also, Your Honor, there's the case of Colonial Pipeline Company versus Morgan, which is found at 263 Southwest 3rd, 827, Tennessee, 2008. So essentially, Your Honor, the position with equal protection clause is when there is an alleged equal protection violation, and it is alleged that the state or the individual acting on behalf of the state has acted outside the scope of its authority, then the sovereign immunity cannot be used as a defense, because the sovereign immunity is only used if you're acting within that scope of authority. And Your Honor, we would offer to the court and submit to the court that that's not the case that's before you. And so
This is not a situation where you're saying that the statute at issue is unconstitutional. It's the exercise of the authority given by the statute that you're asserting is outside of the scope.
right. And Your Honor, we would say it's unlawful and insidious, and use bad debt standard up as arbitrary and capricious, because here we are, Your Honor, basically dealing with an issue in which the current administration has addressed. And so in 2016, the entire administration of the town of Mason leaves. 2018, as Attorney Clayton stated, the people of Mason elected new leadership, and the new leadership has been responsible. The new leadership has attempted to cure the past transgressions of the town of Mason leadership.
Because one of the issues that the state relies on heavily is the increase in the debt, and they give sort of a historical perspective that, you know, the problems were first identified as long ago as the 2011 audit that they received in early 2013, and then the audits indicate an increase up to and including fiscal year 1920. But the point of the town is that through aggressive means, that has been taken back down, and that there's no appreciation or recognition of that.
That's
With
correct.
these, with this correct action.
That's correct. You take in what was at first a $600,000 deficit down to $258,000 under this leadership. And so the town is responsive. The town is addressing repayment to its water sewer fund. And I think this current leadership has taken this very seriously. And if allowed to continue a plan of action, then I think that they will be able to cure what has been done. Equal protection, there were 3 other instances which have been cited in which they have been drastic overtaking finances, and those 3 cases are nowhere near what we're dealing with here. We're talking about a town that had $1,000 in the bank, nowhere near the town of Mason. We're talking about very, very significant and just extraordinary instances where the towns were just falling apart. And you don't have that with the town of Mason. We have new leadership, and what has occurred is that the Comptroller's office perhaps thinks that the new leadership is like the old leadership, and that's just simply not the case. And so the Comptroller comes in, and something that's unheard of, and we're talking about exercise of authority under Section 9-21-403. He asks the town to give up his charge. I mean, just makes him go away. We don't want you anymore. And so, that's just extraordinary. And I don't see, and I've read the state's briefing, I don't see anywhere in any statute that the state has articulated where it says it can come in and just wipe out a city. Especially if the city's leadership has appreciated the issues and they're trying to address the issues. If Comptroller Mumpower could come and just wipe Mason off the face of the earth, then I would argue that he's more powerful than the governor of the Tennessee General Assembly put together.
The state does make a distinction between the other examples that are given in the complaint because of the encroachment upon the utility funds and the special concerns that raises, because statutorily that is not allowed under
7-34-115.
Yes, sir. Thank you. You had that at your fingertips. I had to work for it. Yes.
Yes, ma'am. And so, Your Honor, we appreciate that, and we realize that there are issues which need to be cured, and Mayor Gooden and Vice Mayor Rivers, who are in court today, have taken it seriously. They've driven up to show the court that they take this seriously, Your Honor.
And I appreciate them coming today, and certainly that's apparent.
Also, Your Honor, I report to Gamillion versus Lightfoot. That is a case that is found at 364 U.S. 339, 1960. And basically what it says is the legislative control of municipalities still has to fall within the scope of equal protection and the Constitution. And so the law reads that the equal protection clause of the Tennessee Constitution tracks the equal protection clause of the federal Constitution. So it's one and the same, and I think that law is applicable here. And Your Honor, that just still buttresses the point here is when the state acts outside of its scope, it exceeds its authority, its reading of a statute, and they lose their sovereign immunity, which is the focus here now. So Your Honor, we think that subject matter jurisdiction is not an issue. You have it. And we think that when you look at the prongs of Rule 65, we also believe, Your Honor, that there is enough in the record through the affidavits and what's already submitted to the court to issue a temporary injunction. And Your Honor, we understand that under Rule 65, you can stop an action and you can force an action.
Yes, sir.
So the injunctive powers of Chancery Court are very far and wide.
They also allow some creativity.
Right.
Which is why I asked Mr. Clayton about sort of the particulars of the corrective action plan, which were highlighted in not only the complaint, but in the sworn statements that were provided with the complaint by Mayor Gooden and Vice Mayor Rivers and so forth, and your financial officer as well,
Ms. Marshall.
Ms. Marshall. Yes, talking about emergency circumstances, how far $100 is going to get a city in terms of expenditures, putting fuel in city vehicles, that kind of thing.
Right. And for issues, Your Honor, we just had a tornado 2 weeks ago. Luckily, nothing was destroyed, but it could happen tomorrow.
There was some reference to a water main
Water main.
burst, maybe during the winter.
Yes, ma'am. And so that really ties the hands of this administration, which again is trying to do the right thing. They appreciate the gravity and seriousness of what has occurred. They've taken very substantial corrective actions, $200,000 plus payment, and they have made a payment already as far as it relates to the monthly payments, which is a strain. It's a strain, Your Honor.
The $9,500 payment.
Correct. But out of arrest and out of fear that his charter will be taken, you know, they're pushed into doing something like this, which is probably not in the best interest of the town, hence we're before you, Your Honor. And so when we look at a declaratory judgment, I know the state has briefed that as well. And I'll list specifically as it relates to the deck action and sovereign immunity. And basically, it says here, no court of the state should have any power, jurisdiction, or authority to entertain any suit against the state or against any officer of the state acting by authority of the state. Acting by authority of the state, Aaron. This is the sweet spot here. Authority of the state. Does Comptroller Mumpower, or the Office of the Comptroller, have the right to ask a city to give up its township as a result of issues that are going on financially, especially when corrective action has been taken and is currently being taken? And also, I would say, is it within the statute of 9-21-403 or 7-34-115 for the state to tell the town anything over $100 has to be approved by the comptroller's office?
I mean, the statute doesn't have any particulars. It's broad and probably purposely so, because every circumstance requires a unique remedy or a unique set of corrective action items.
Yes, ma'am. And to that point, if we are relying on the statute, and so the interpretation of it is very key, I think, for your Honor's determination. And so when you look at the likelihood of success, which is a factor of Rule 65, essentially, Your Honor, case law is plentiful that says if the statute does not say you can do it, then it is intentionally omitted. So if either one of these statutes do not say clearly, unambiguously, that the comptroller's office can come and demand what it has demanded thus far, and that was intentionally omitted by the Tennessee General Assembly, and we think that it is an overread of both statutes. And so the likelihood of success, Your Honor, is where we are. We feel, Your Honor, that once you read all the case law and look at the actions of the comptroller's office, there's a great likelihood of success for the township, because the office of the comptroller does not have solid ground in either of the two statutes articulated for the conduct that is engaged upon and for the actions that they have undertaken as it relates to this case. No express grant of authority to ask the town to give up its charter, to say to that town anything over $100, you have to get our approval. There's nothing a town can do, even a town of less than 1,500. There's nothing a town can do that's under $100. That basically is control. That basically is control. And
It's the equivalent, it
Right.
feels like, of the comptroller controlling all aspects of the town's business.
correct.
And then the issue sort of becomes, does the comptroller have that authority
Right.
statutorily?
And we say it doesn't. Your Honor, the town of Mason elected a mayor to sit right there. And so basically, they did not elect the comptroller's office to run its financial affairs to that degree, and that would be an overread of both statutes. And so, Your Honor, we think that the likelihood of success is there. Also, Your Honor, it's allowed to briefly articulate or put before the court Arlington Heights, which is a Sixth Circuit case, which delves a little bit into sort of the racial distinction here. The leadership has just switched, as Your Honor heard, from 2015-16 to now. The majority of the leadership now is African American. The majority of the leadership when all these things occurred was not African American. And so I think that is a point, because if the comptroller was serious about this, why not have come in 7 years ago and asked for the charter to be relinquished? But now you have African American leadership and you have FOR. And FOR represents a wonderful, great opportunity for this community, which the comptroller has said, well, you can't take that opportunity because we want you to go away. And so, Your Honor, we think that there is an aspect of discriminatory treatment when you look at this case, and we, Your Honor, in our papers will definitely focus on that.
And tell me again when you think, if given the opportunity to brief, which I certainly would give you, but keeping in mind the sense of urgency of getting a decision, when would you want to be given a deadline to do that?
Your Honor, we think that we could get you something by Monday.
Okay.
That would work. Yes, ma'am. And Your Honor, I learned in law school that UT not to overstay my welcome, so I'll quickly start my wrap up here, and we still reserve the time for rebuttal. But the last point, Your Honor, under Rule 65 is balancing the harms and public interest. And I think Your Honor has heard this time and time again, but in one of the letters from Director Knox, she says if it's a true emergency, then they will grant the relief of over $100.
And your financial director needs to be available 24/7 to make that request.
Right, and she's part-time. And so that is a tremendous burden on her. And, Your Honor, it just gets to where it's a true emergency. So that's not defined. What is a true emergency? It's not articulated in the letter. A true emergency could be anything that the comptroller's office wants it to be, which again, I think is unlawful and insidious, and if you take the lesser standard, it's arbitrary and capricious, because true emergency is what they say it is, and not what the town deems it to be. And so there is a public interest involved here. If we think about it like this, if the comptroller's office could come in and deem what is a true emergency, to tell a town everything over 100 needs to be approved, the comptroller office can essentially take over any city in this state. And and basically run that city irrespective of the leadership. It doesn't matter that you have a mayor or city council. But I think there are issues there. One, I can tell you to give up your charter. Two, if you don't, I can tell you that anything that's over $100, I have to approve it. And that may be a day, 2 days, or a week. And three, I get to tell you where a true emergency is.
And of course, we don't know where the $100 came in. There are smart people who work for the comptroller who have knowledge of accounting principles and auditing skills and so forth. And I guess that was tailored to the size of the city. I don't know that. We don't have a record developed enough to determine that. But it's still,
Quite small.
from your client's perspective, a very small amount for anybody to operate a business.
Yes, ma'am. That is absolutely right. And a final note here, Your Honor, just as I was walking over your beautiful city, I love coming to Nashville. Don't tell my folks in Memphis that.
That's right, that's right. Ongoing competition.
Yes, ma'am. As I read the statute here that the state will rely upon, and I'm looking at their briefing, it basically says the comptroller can come in and do three things. If you're reading 9-21-403C,
Yes, sir.
it says, Your Honor, that they should have the power to adjust estimates. And this is going forward. They should have the power to reduce expenditures. They should have the power to issue tax levies. I would presume that when the respondent takes the podium, Your Honor, they would say that under their ability to direct the reduction of expenditures, they have the right to say anything over $100 has to be approved. But I think that is a overreading of the statute. If you want to reduce expenditures, hey, don't spend so much on cars going forward, or use this type of system as opposed to that type of system to reduce your expenditures by this amount. Planned out, something that you can touch, something that's concrete, that's not arbitrary. Something where they're not deciding if it's a true emergency or not. And so the reduction of expenditures does not equate to everything that's over $100. I get to tell you what to do with it or not, or define what a true emergency is. So, Your Honor, I think that that's an overread of 9-21-403, and because of that, this court has subject matter jurisdiction. Sovereign immunity does not protect the state because their interpretation is outside of the authority granted in the statute. If the Tennessee General Assembly wanted to grant the Office of the Comptrollers this wide range of ability and discretion, we would put it in the statute. It's not in the statute. Therefore, Your Honor, under Rule 65, we would submit to the court that an injunction is needed.
Can you give me the specifics of what you request the injunction to say? Because it could be as far as finding the corrective action plan not enforceable in total. It could be in tailoring it. And you may want to think about it, maybe that could be sort of the last word. But again, the creativity of this kind of remedy is one of the beauties of Rule 65. So I would be interested in what the specifics are up for that request so that I can consider that in the motion.
Thank you, Your Honor. And I appreciate you asking. And one of the first things I did, Your Honor, was walk around here and shake the hands of my able co-counsel and say, we're willing to negotiate a settlement. We don't have to be where we are. We are, on behalf of the town, willing and available to talk and to come up with an action that is reasonable and an action that is logical and does not harm the town. And I would tell Your Honor that we will seek a resolution in good faith as far as settlement. But for this morning, Your Honor, if Your Honor were to fashion an injunction, one we would say no oversight of expenditures over 100. I just think, Your Honor, that's pretty.
That item in particular is
Right.
one of significant concern for your client.
Correct. Yes, and it's offensive, Your Honor, and I would say that needs to be stricken, period. Also, that puts a heavy burden on the part-time financial director, Ms. Marshall. Also, Your Honor, these payments were were given or were agreed upon out of the rest. I mean, what do you do when, the comptroller's office is saying, well, you need to give up your charter, and then you write all the townships saying you need to go away. And so you're trying to do whatever you can to survive.
So the request would be to modify the $9,564, the first spend, $9,564 times 27 months to repay, to modify that payment plan, or to modify that as having to be the town's priority spending.
Correct. And that's absolutely right. And keep in mind, Your Honor, that they're asking for this before other expenses of payroll can be met. And so how can you do anything if you can't pay your employees?
Right, that does not have the non-payroll
Right.
modifier with it that the $100 does.
Right.
It's the first
It's the first
money spent.
Yes, ma'am. Absolutely. And this is not going to the general fund, which is the main operating account of the town. This is going to the water sewer fund. And we understand and appreciate that the money should not have flowed out, and that's something that we can remedy. But again, because of this one separate fund, you're taking hold of the entire general fund to such a draconian extent.
Because there are other things in the corrective action plan, such as the town will no longer use the water and sewer fund for general expenditures, which, as we've already discussed, is contrary to Tennessee Code 7-34-115. That money is supposed to stay within the fund, and if there's a surplus, it's supposed to be used to lower the rates, not go to general expenses.
Right.
And so that's part of the corrective action plan, and it doesn't sound to me that that is one that is offending or that is an issue.
Your Honor, the leadership takes this issue seriously, and it is working day and night to address it, and they intend to address it. And Your Honor, you've seen it being addressed.
And having a balanced budget and finishing the back audits is also something that sounds like the town leadership has been focused on, also not necessarily an offending component of the corrective action plan.
That's correct, Your Honor.
Thank you. I'll be pleased to hear from you after I hear from the state.
Thank you, Your Honor.
I think that'll autofocus for you, or you might need to,
It's for later, I just wanted to put it up, Your Honor.
no, I saw that in your materials. That's a very helpful illustration.
Good morning, Your Honor.
Good morning.
My name is J.P. Urban. Like I said, I'm with the Tennessee Attorney General's Office, and I represent Comptroller Mumpower in this matter. This is a case about a town that has struggled and continues to struggle with its finances and the Comptroller's actions to help the town move towards financial stability. The town of Mason requested in its petition that the court grant its first application for injunctive relief in the form of a temporary restraining order. We have not received any motion or application for a temporary restraining order.
That's why I didn't bring it. Friday afternoon, because our rules require notice or a sworn explanation of why notice is infeasible or inappropriate, and we did not have that, and I thought the state's participation was pretty important for the court granted any relief.
Thank you, Your Honor. And to the extent possible, in our briefings, we responded to the petition as if it was an application for a temporary restraining order in order to move this forward. I just wanted to note at the outset, if the town is able to submit a brief, since we haven't had the opportunity to review their legal arguments, since there weren't really any in the petition, I request that we have a short opportunity to respond to that brief. I don't want to delay things or protract the court's decision further, but just in fairness, if that would be a possibility.
Yeah, I'll think about that. Maybe a brief reply brief to be given, to be filed within 24 hours or something like that. You hit, obviously, the substantive legal points that are the primary defense, at least as an initial matter for the state.
Thank you, Your Honor. We would appreciate that. A temporary restraining order or temporary injunction is an extraordinary form of relief that must be analyzed with great caution. The burden is on the town to show that its rights are being violated by the comptroller and that the town will suffer irreparable harm or injury pending a final judgment in the lawsuit. Courts, as opposing counsel indicated, rely on 4 factors to make this decision, including the injury to the petitioner, the balance of the harms between the parties, the petitioner's likelihood of success, and the public interest. In this case, all 4 factors we submit weigh in favor of the comptroller. I will discuss likelihood of success on the merits first. And I guess before we can get to the facts of the case as a threshold matter, as Your Honor mentioned, the comptroller's raised issues of subject matter jurisdiction because in general, under Article 1, Section 17 of the Tennessee Constitution, the state is immune from suit unless the legislature directs otherwise. So in the briefing, I went through the 3 statutes cited by the town. That includes Title 16, Tennessee Code Annotated 1611-103, which is the Chancery Court's general jurisdiction statute for disputes in equity of amounts $50 or more. This case does not involve a dispute of money between the parties, and that statute is a general one, so it's not applied directly to the state. And so that statute does not give the court jurisdiction. Next to the town.
So if it's not a dispute about money, all the sovereign immunity cases that talk about claims to try to get to the treasury of the state would not be applicable, you're right?
Your Honor, I think in general, because the state needs to extend its resources to defend the case, it still, to some extent, does involve the treasury. But the constitutional provision, I acknowledge the case law you refer to. But in general, the principle in Article 1, Section 17, that suit may not be granted against the state unless it may be granted as the legislature so directs. Here, just the legislature has not directed the suit come under the court's jurisdiction. Next, the court site, or the town cites Tennessee Code Annotated Section 2914-102A. This is the Declaratory Judgment Act, and it's well established, and the Court of Appeals in Huntley v. Rose stated, "It is well settled that our courts may not entertain an action for declaratory judgment against state officers under this section." So that statute does not give the court subject matter jurisdiction here. Finally, the town cites Tennessee.
Well, and you heard your opposing counsel's argument that their allegation is that the comptroller was acting outside of his authority, and that is where they see that statute and that principle of sovereign immunity not to be applicable here.
Yes, Your Honor, and I do want to address that, and I'll talk about
Okay.
that briefly. The cases under, for instance, Section 1983 of the United States Code deal with violations of civil rights, including equal protection under the 14th Amendment. Here, we're talking about the town as the petitioner here, so the analysis needs to go to who's bringing this suit. Here it is a local government, and let me turn real quick to my
I'm
case.
sorry to get you out of your argument.
No problem.
But you're hitting right on your points, which I've been thinking about, so I'm so glad to hear your response.
Thank you, Your Honor. The federal case law, including case law in the Sixth Circuit in South Macomb Disposal Authority v. Washington Township, that's a 1986 case. That court stated, the nature of the relationship between a public corporation and its creating state has led the court to conclude that a municipal corporation cannot invoke the protection of the 14th Amendment against its own state. That cites the case of the city of Newark versus New Jersey, and that was a U.S. Supreme Court case from 1923 that held the same. And so here we have a town, which is a political subdivision of the state of Tennessee that operates under the laws of the state, bringing a suit purportedly under the Equal Protection Clause of the 14th Amendment, and that lineup of parties is incompatible with the Sixth Circuit Supreme Court's analysis.
And back to the sovereign immunity issue on the deck action. So their allegation, the town's allegation is that the state doesn't have immunity in this case because the officer in their position was acting outside of his authority, and that removes the sovereign immunity And then I would say that it appears that they're only looking for declaratory relief, even though there is something in the front here about damages. I'm not sure what that ties to. But, you know, again, there's the case law that talks about suits that seek to reach the treasury of the state versus suits that are looking for particular relief. But not a colonial pipeline case where you're challenging the constitutionality, sort of a hybrid.
Your Honor, I guess first, at the outset here, the comptroller is not acting outside of his authority, and I'll go into detail.
I appreciate that that's the state's position, of course, of course.
And so, but in the cases, and again, we don't have the case law in front of us that opposing counsel cited, and so that's why we would like to have, there's some lines on the screen, so I apologize.
Oh, that's okay. It's very sensitive.
The citations, we need to do research on those, but I believe that case law that the General Jurisprudence Council was discussing was in 1983 actions in cases where the petitioner or the plaintiff had standing to bring such an action.
Because a officer of the state or the federal government or whatever, whether it's a police officer or somebody else, violated civil rights, which takes them outside of the cloak of the sovereign immunity.
Yes, Your Honor, in general, and as I mentioned, that's usually under statutes like Section 1983 actions where the federal government has removed sovereign immunity for those types of cases. But because the town has brought this action against the state, and the town is a political subdivision of the state, those cases and that constitutional provision doesn't apply. And so, without jurisdiction, the likelihood of success analysis should end. However, I would like to discuss the underlying issues, in part to set the record straight, and in part to move the parties forward to hopefully bring a better financial situation for the town. In Tennessee, local governments, including the town of Mason, like I said, are political subdivisions of the state. As such, they must adopt and maintain balanced budgets and submit an annual budget to the comptroller. Local governments often also operate utility companies like water, sewer, and gas, and local governments are prohibited from using the funds dedicated to those utilities to fund the operations of the general government. In other words, the municipality cannot transfer money from the utility fund into the general fund to pay for its operations. This framework is set out, as was already discussed, in Tennessee Code Annotated Section 734-115. And a municipality that illegally transfers funds from its general fund or its utility fund to a general fund violates that statute. And in subsection 115F, I'm just going to recite this because I think each part of it is important. That section provides, if a municipality violates this section, it must repay any funds illegally transferred. If the municipality does not have sufficient funds to repay any funds illegally transferred, the municipality is required to submit a plan covering a period not to exceed 5 years in which to repay the funds. The plan shall be submitted to and approved by the Comptroller of the Treasury or the Comptroller's designee. Upon discovery of such violation through an audit, any city official in violation of this section is subject to ouster under Title 8, Chapter 47. So with that statute in mind and that general framework for municipalities in Tennessee, I'd like to discuss Mason in particular. Since at least 2011, the town has owed a balance to its utility funds. These are called inter-fund loan balances, you may have seen through the briefing and materials. The Office of Local Government Finance at the Comptroller, I'll call it LGF, tracks local governments who have violated 734-115 and improperly used utility funds. And in 2013, LGF asked the town of Mason to submit a corrective action plan to remedy its violation of 734-115. The town provided a draft plan, but ultimately the comptroller refused that plan because the town had an incomplete budget. You see the comptroller reviews all these financials to get a holistic picture of the town's finances, and so it was not able to approve that plan. In 2015, LGF again requested the town to submit a new corrective action plan, which LGF approved in December of that year. Between 2016 and 2019, the town reported to LGF that repayments were being made to the utility funds to bring the town into compliance with 734-115. Also during that time, the current vice mayor was an alder person. The current mayor, Mayor Annette Gooden, was an alderman from 2016 until he was elected as mayor in 2019, I believe, it could be 2018. When he was elected mayor, the town's bookkeeping firm was made part of the town's financial team, and that was 2016. And in the town's financial officer, Rita Marshall was hired, and that was in 2019. Now that we've made it to 2019 in the chronology of this case, it's a good time to discuss the importance of audited financials. In reviewing local government budgets, the comptroller relies heavily on audited government financials from earlier periods. It's impossible to know if a budget is balanced or based on true figures unless the comptroller is looking at verifiable data, and that is in the form of audited financials.
Which is one reason, as I understand it, from reading the state's representatives who submitted sworn statements, that the gravity of the situation maybe was not as apparent as it was occurring because of this lagging of audited financials.
Yes, Your Honor, and I think if we look at these two charts here, I think it illustrates that point. On the top graph, we have a chart that indicates with the blue line the amount of money the town owed to its utility funds. That's water and gas mainly, and then the bottom line is money the town owed to other funds like the State Street Aid Fund and the Drug Fund. But the blue line indicates that from 2011 through 2016, there were increases in the amount of money being used by the town out of those utility funds. And then between 2016 and 2020, that number skyrocketed dramatically, rising to nearly $700,000 in 2019. And these numbers, this graph was created by Steve Osborne, who is a senior financial analyst for the Comptroller's Office. And the data included there was based on audited financials received by the Comptroller's Office. For 2020, that is still a draft, so that those numbers aren't verified yet. And there are audits throughout that period that the auditors actually had to disclaim because the underlying financial data was not accurate enough to make certified audits. But that's the best information the comptroller had to use, and it indicates a rapid rise in the interfund loans to the utilities.
But I guess I was a little confused about that because your chart stops in 2020, and maybe it's only based on audited financials, but the repayment plan assumes that the debt is that 258, 220 number. So really, if we continue to now, that blue line would come way back down, right?
Based on that information, yes, Your Honor, it would be down. The issue is the comptroller can't necessarily rely on those discussions as verifiable data for making decisions going forward.
Until it gets the audit?
Until it gets the audits, and since they are so far behind on the audits, that is the main reason for the comptroller requesting such frequent periodic information so that they can get a handle on the ongoing operation of the town.
So is that disputed? Because I'm looking at the corrective action plan, and it says that the estimated unpaid balance is the 258 number, and it appears to me that's what the repayment expectations are based off of.
Yes,
I want
ma'am.
to make sure I'm looking at the right correspondence.
Yes, the March 28, 2022
Okay.
letter from Ms. Betsy Knotts is the current updated corrective action plan that we are here about today.
Okay.
So that estimated number, it is what it is, it's an estimated number, and so the payments are based on that number. If that number is inaccurate, then the payments could be required to be a lot more, but for now, that is the data, the unverified data they have.
Okay. Please go ahead and continue.
Thank you, Your Honor. So in 2015, LGF again requested the town to submit a new corrective action plan. Sorry, I went back in my notes here.
Where are we on the calendar? Where are we in the chronology? I'm sorry.
We are at 2019.
Okay, thank you.
Thanks. So again, stressing the importance of audited financials. They're so important for the comptroller to know whether a budget is accurate or not, and where the town stands in its finances. And the town has not provided up-to-date audits for many years. For example, the audit for the town's fiscal year 2017 audit, which is July 1, 2016 through June 30, 2017, was not presented to the comptroller until 2020. The comptroller received a copy of fiscal year 2018 audit in late 2020, and the Comptroller received a copy of fiscal year 2019's audit in June 2021. And so, without this verifiable data, it's hard for the Comptroller to operate and analyze funds. And so, in January 2021, LGF approved the town's 2021 corrective action plan, which included a condition that the town needed to submit delinquent audits in a timely manner, and that the town must submit a detailed assessment of interfund balances. So the Comptroller needed up-to-date information of those balances because the information it was receiving in a verified way was several years old, and so they were really looking in the past. In May 2021, LGF received a draft of the fiscal year 2019 audit, and they were alarmed to see increased interfund loans. Again, these transfers from the utility funds to the general fund, and they had ballooned dramatically, as the chart indicates.
And what was the year on the audit it was receiving?
That was the fiscal year 2019 audit, so that would be July 1, 2018 through June 30, 2019. And that was just a draft at that point.
And that showed dramatic increase, which is on the chart, which is that peak in your blue line. Is that right?
It is the year before, yes, that's the peak, yes, Your Honor.
Okay, it's hard when we're talking about calendar years and fiscal years to figure that out.
Yes,
Okay.
And so the amount had doubled from 2018 to 2019 fiscal years, from nearly $300,000 to over $600,000 of utility funds. And so the general fund also ran large deficits each year during that time period, and that is the lower graph here. And so it is really a corollary to the utility funds interfund balances. You see that in 2011, 2012, the town was near zero in terms of its assets minus liabilities, and that started going down, and then in 2016 rapidly decreased into the draft 2020 audit we have here, where we're near negative $500,000 in the general fund balance.
And the general fund is just the money that they have in the bank, is that reserves, what is that referred to?
It is the money they have available to them. It is assets minus liabilities, and so because there's
So it's not cash, it's, if you look at the liabilities and because the debt to the water and sewer and gas funds have gone so high,
yes,
that caused a precipitous drop in this number.
that's correct. That's
Okay,
my
got
understanding.
it, thank you.
And so later in June 2021, the town filed its fiscal year. Let me go back one moment. In June 2021, I think it was June 9th, 2021, LGF staff met with the town's officials with the intent to present a PowerPoint detailing how dire the town's financial condition had become. And that PowerPoint is Exhibit D to Mr. Steve Osborne's affidavit. And at that meeting, the town assured LGF that the interfund loan payable to the town's water and sewer fund, which is the largest utility fund to which interfund balances were owed, had been fully paid after the 2018-2019 fiscal year, and that the 2021 corrective action plan had been implemented. So at that point, LGF staff were told that there was no balance left to the water and sewer fund. But later in June 2021, the town filed its final fiscal year 2019 audit, which confirmed that the water and sewer fund was indeed over $600,000 as of fiscal year 2019. LGF notified the town in September 2021 that it could not approve the town's 2022 budget because LGF did not verify the town's current financial status. The town's auditor then notified LGF in November of 2021 that the interfund loan had not been paid off and that it was estimated to be up to approximately $700,000. And so it's clear from these graphs and that story so far that the town had for a long time essentially been using its utility funds as an open line of credit to fund the town's operations and was not paying that back, that those debts were increasing throughout that time. In February 2022, with all of this in mind, the Comptroller visited Mason and notified town officials that the town would be subject to heightened financial supervision if it chose to retain its charter, which it chose to do.
I'm sorry, can you say that date again?
That was in February 2022.
This is the meeting,
Yes,
when the Comptroller personally went, it sounds like.
yes, Your Honor.
Okay,
February 8th.
February 8th, thank you.
And And so the townspeople and the town officials were given a choice between heightened financial supervision to attempt to bring its financials, which were in dire condition, into a better shape, or to retain its charter. And again, the town, as it had a right to do, voted to retain its charter.
It puts it a little bit in a choice, a no-win choice situation, it seems like.
Your Honor, I think the no-win at that moment, it is a choice. It's a very difficult choice. And the town's finances were in such dire condition, though, that something had to be done. And so that brings the comptroller forward to taking the actions he took after that meeting. And so the town chose to remain a town, which again, the town was free to do and has done. The comptroller cannot remove the charter of the town and never tried to. The town still has its charter. The town.
He was offering that as an alternative to the heightened financial oversight.
Yes, sir. On March 22nd, 2022, a meeting occurred between the comptroller, LGF, and town officials in Jackson, Tennessee. That meeting was positive from the perspective of the comptroller's staff. Good discussions were had, and the town officials were told that heightened supervision would end when the town's 2023 budget was approved and a 2021 audit was finalized. Taking into account the discussions from the March 22nd meeting, Betsy Knotts, the Director of Local Government Finance, sent the March 28th, 2022 letter to the town laying out the updated corrective action plan.
And isn't that the first time that the $100 limit and the first dollars to be paid towards the debt, those were components that were added and not previously discussed? Is that correct?
Your Honor, I believe they were discussed, and I would have to verify that fact, but this is the first time in a written corrective action plan that came into discussion.
That seems to be the real touchstone for the adverse situation here.
Yes, Your Honor, and I will discuss that in detail. So this March 28th, 2022 letter was sent out to the town, and on March 29th, a meeting occurred between LGF and the town's bookkeepers, and they planned to have another meeting on April 1st, which was last Friday. But the town's representatives did not show up to that virtual meeting, and this petition was filed later that day. The corrective action plan that is not sent on March 28th is a means to work more closely with the town to improve its finances. The verifiable data available to the comptroller showed that the town's condition was getting worse. The LGF staff also found out that the core civic prison in Mason had closed at the end of September 2021. And that prison amounted for as much as a third of the utility revenue for the town. And so here we have a town with large interfund balances to its utilities, and the utility was going to lose a third of its revenue.
Well, so if that is a relevant factor, why wouldn't the Blue Oval project be a relevant factor to consider of positive change to come?
Your Honor, I think it is the Blue Oval project is likely to bring positive change to the entire area. And it would be wise for the town to have its finances in great shape when people start moving in, when people start buying property, opening restaurants, whatever happens around that project. That project, I believe, just started moving dirt a few months ago. And so, it's a long time before people really move in. You'll have construction workers, but the towns in the area will benefit from the existence of the Blue Oval project. But that fact doesn't bear on the financial condition of Mason right now, and the facts that led to the financial condition of Mason right now. And so right now we have a major employer and utility payer in the town closing in September of 2021, which from the perspective of the comptroller exacerbated the issues that Mason would be facing. All of these circumstances considered, the comptroller determined his next step was to utilize his authority under Tennessee Code Annotated Section 921-403C, in addition to his approval authority under Tennessee Code Annotated Section 734-115F. Section 921-403C permits the comptroller to, quote, require any periodic information from a town government, end quote. And in the case of a town with a non-approved budget, like the town of Mason, the comptroller may, quote, direct the governing body of the local government to adjust its estimates, to reduce expenditures, or to make additional tax levies, end quote. The comptroller may continue to use his authority under that statute until he's satisfied the budget complies with Title 19, Chapter 21. Each of the requirements in the March 28th updated corrective action plan is consistent with those two statutes, 921-403C and 734-115F. The plan first requires repayment, and maybe help if I put this on the overhead.
Okay.
So the updated corrective action plan starts here. And the first set of requirements is to begin repayment of the balance of the utility funds within 27 months. And the monthly payment must be made before other expenditures. The comptroller under 734-115.
Before any other expenditures, so
Yes.
not, so the very first dime until that's paid is what the town has to do, is that right?
Yes, Your Honor.
Okay.
And that is part of the plan that the comptroller has approved under 734-115F, which requires that the plan to repay the money within 5 years must be approved by the comptroller. And I'll note that originally in a memo submitted by Mason to the town,
They proposed an even more aggressive repayment, or 26 months rather than 27 months.
that's right, Your Honor, and originally, the town proposed this 26-month period, which would be a $10,100 per month monthly payments towards the utility funds, and the comptroller reduced that to, or increased the payment period to lower that amount under $10,000.
I think the concern, and Mr. Turner will correct me if I'm wrong, I'm sure, is this, what they perceive to be sort of hyper control of saying that those have to be the first dollar spent rather than using the discretion to pay it kindly, but not as those first dollars. That's a particular requirement that was added by the comptroller's office.
Yes, Your Honor, and I think that that requirement makes sense based on historical look at this whole scenario. We've a town that for many years borrowed from its utility funds, and so the money they were spending was coming from the utility funds. And so without making that the first dollar paid back, the comptroller's no assurance that money's actually going to get paid back. Because in addition to the money borrowed from the utility accounts, the town was spending too much. And so that is reflected in the rest of the plan. But to make your debt the first payment, to make that serious debt that in violation of statute, your first payment is a real solution to a serious problem, which was this great debt owed to the utilities.
Right, and so the two goals of the comptroller were to get the utility fund paid back and to get expenditures under control so they can have a balanced budget.
That's right, Your Honor. Those are the two main purposes of the comptroller in working with this town, working with any town or county in the state to make sure there's a balanced budget so that the government can provide services for the town in a fiscally responsible way. And so the next item on the updated corrective action plan is the recurring submissions, which was to begin on April 4th, 2022. Recurring submissions are authorized by Section 921-403C, which gives the comptroller the ability to require any periodical information from the town. And so that the submissions are well within the authority of the comptroller. And so the item in the plan, as we've discussed, that the town specifically complains of is the requirement that the comptroller approve expenses, including all non-payroll expenses over $100. Although LGF has not yet declined an expense, if LGF reviewed an expense and determined that the expense must not be paid because it's injurious to the progress for the town, that determination is consistent with the comptroller's authority to direct the town to, quote, reduce expenditures under 921-430C. And so that statute that gives the comptroller the ability to reduce expenditures, if the only thing the comptroller had the power to do is to tell a town, stop spending as much, that is not an effective way to get any set of finances under control, especially finances that have a long history of being in poor condition. And so the comptroller needed to set up a framework, considering all the factors at issue in the town's finances. And he came up with, he and LG Local Government Finance came up with this plan that involved the approval of non-payroll expenses over $100. And, you know, in reality, the way this will work, and there will be discussions between the town and the comptroller.
This is really new, so it hasn't really sorted out what the process is gonna be, because it was started Monday.
Yes, Your Honor, yes. And so we, the comptrollers received one submission, but no expense approvals from the town as far as I am aware at this point. But the town may submit its weekly budget, or often 2 weeks in advance, submit its budget for what it's going to be spending over that time period. And that would include all foreseeable expenses laid out for the comptroller. This is our payroll, these are the expenses we expect to incur, the types of things that are unknown but foreseeable. So for instance, the comptroller discussed with the town, what if the police need to tow a car? Well, that expense is something that should be built into a balanced budget. It's an expense that is unknown but foreseeable, the police tow cars. And so once this process works itself out and the town and comptroller working together in this process, the town will be able to submit all of its items it intends to spend. And then when something comes up that's not an emergency but was not budgeted for, that's when they would submit an expense approval. The town spoke of what happens in an emergency, if a tornado does come through. And Ms. Knotts clarified in her email on Saturday that, and in discussions with the town previously, that emergencies are emergencies. If there's an emergency, we just ask the town to call local government finance either before if possible or immediately after the expenditure to discuss it, because it needs to be taken into consideration by the comptroller in analyzing the ongoing finances of the town.
So what if it happens on Saturday night? I don't know, and I'm not asking you on the record to give me her cell phone number, but has that kind of ability to reach her been sussed out between the parties?
I don't know whether Ms. Knotts is available Saturday night specifically has been sussed out. I know from briefing this matter that she is, but
You've certainly taken a little bit of that to her on Saturday night.
Yes, Your Honor. But the requirement that an emergency comes up, if it is in that middle of the night type of scenario where you have to buy water or get into construction equipment for a tornado recovery, that's the type of thing you call Monday and talk to LGF about. This is all hypothetical, but in true emergencies, the town will do what it needs to do, and that is something that none of us can control. And so, for that, calling the comptroller's office as soon after a true emergency expense as possible is within the conception of this corrective action plan. And so, with this $100 non-payroll expense authority, again, it is a direction from the comptroller to reduce expenditures if the comptroller deems an expense to be, not in the town's fiscal interest. If it's spending too much money on a particular thing. Ideally, there will be no projections of expenditures. The town will submit good bi-weekly budgets, and the finances will improve quickly, and everyone will be able to move on as soon as possible when the town of Mason has a 2023 approved budget and the 2021 audit has been finalized and delivered.
And that's what the 2023 budget is depending on, is that next audit being finalized?
Yes, Your Honor, yes.
Because there's one more that's in the pipeline, right?
So the 2020 audit, we have a draft of, and it's been attached to materials, but as of yesterday, at least, it has not been finalized and delivered. And so 2020 will be coming soon, and that's 2019 through 2020. And the 2021 budget, which is 2020 through 21, is being worked on as well, but we don't expect that imminently.
But just remind me what the trigger is to review and potentially approve the outstanding budget that's the one that you have in draft being finalized?
The one in draft would have been necessary to approve the 2022 budget, the one that's currently being operated under, if my math's correct here. Instead of the 2021 audited financials are important for establishing the 2023 budget. So that's why those two are.
And the 2023 budget is the trigger to, the approval of the 2023 budget is the trigger to take the town off corrective action, is that right?
That's what's been discussed. Yes,
Okay,
ma'am.
that's what I'm trying to figure out is what has to happen for circumstances to change.
Yes, ma'am. And so, turning then to the balancing of the harms and the public interest, having, I think, established the Comptroller's authority, the town asserts that Comptroller is treating it differently than other localities, and that the updated corrective action plan prevents it from spending in emergencies, and that the corrective action plan will otherwise harm the town. First, as I mentioned earlier, the local government doesn't have rights under the Equal Protection Clause, and so there's no cognizable claim there, but the Comptroller simply isn't giving the town unequal treatment. But the town is being treated similar to other localities have been treated in the past. Though again, I have to stress that each corrective action plan must be created based on the facts on the ground. Here we have the town taking from its utility fund, there's a large balance to it in addition to running deficits, and having to make payments back to its utility fund. So it's a really complicated budgeting process, and the Comptroller wants to help. That's his purpose, that's his statutory duty. And so the affidavits of Betsy Knotts and Steve Osborne demonstrate that in similar conditions in Van Buren County in the city of Jellicoe, Comptroller's office required expense approvals. And I attached to the affidavit of
And in this case, Jellicoe owed a whole bunch of money to the Internal Revenue Service.
yes,
It
Your Honor.
was not a utility issue, but it was one that I suspect could be viewed as just as serious.
Yes, Your Honor. And yes, there was a large debt to the Internal Revenue Service there, and in that case, the Comptroller assisted the town of Jellicoe, the city of Jellicoe, with issuing funding bonds to pay off its debt and move forward.
Which is not an option we have here.
That's correct, Your Honor, because the amount owed from the town of Mason to its public utility accounts is not a true debt. It's a violative expense, and these funding bonds aren't an option to pay back its utility funds. So it needs to do that through budgeting and through.
In other words,
payments.
in that case, because it was a third party, the IRS that was owed money, issuing bonds was an option, but here where it's from one bucket to another bucket within the town's control, issuing bonds is not an option.
Yes, Your Honor.
Okay. And then what was the other circumstance that was included in the complaint?
The Van Buren County was another county that was a county that was in rough financial condition. It was running out of money, but it was running out of money, but it didn't borrow from its utility funds to fund its government. And so it's hard to compare the town of Mason to the city of the county of Van Buren. But in the Van Buren County instance, the Comptroller also required expense approvals. And so in both the town of Jellicoe and the county of Van Buren, the financial conditions of those localities improved. The town of Jellicoe was out from heightened supervision in 2018 after the funding board. I believe work is still being done with Van Buren County, but it has improved during the time that the Comptroller's worked with it. And so finally, the town, almost finally, the town will not be harmed by the corrective action plan. To the contrary, it stands to benefit. The Comptroller and LGF are the state's financial experts and lead auditors, and they assist all local governments in establishing responsible financial practices and operating under balanced budgets. Through years of experience in town financials, LGF and the Comptroller determined that the March 28th updated corrective action plan is the best method right now to get a full understanding of the town's financial condition and hopefully help prevent matters from getting worse and even improve them. The town's stands only to benefit from the comptroller's guidance, and residents and the public interest will suffer if the town does not improve financially. The town's request for a restraining order should therefore be denied. And one item that I left out earlier, another statute cited by the town was for subject matter jurisdiction was 45322H.
But Administrative Procedures Act,
Yes, Your Honor.
judicial review provision.
Yes, and so you'll see that statute is applied for reviewing contested cases that come out of administrative agencies, subject licenses being revoked by agencies. This is not an appeal from a contested case, and so that statute likewise didn't apply. But with that, Your Honor, the injunction should be denied.
Thank you, and you're requesting the opportunity to have a brief response period to any submission by the town.
Yes, Your Honor.
for the court rules.
Yes, Your Honor, that would be helpful. Thank you.
All right, I'd be pleased to hear from either Mr. Turner or Mr. Clayton.
Nice, now the afternoon, so very briefly.
My goodness, I didn't even look at the clock. How riveting you guys.
Thank you, ma'am. So I think that what happened just did happen, and we knew that the state was painting rosy pictures. However, in Van Buren or Jellicoe, those towns or county were not asked to give up. Well, I don't think a county can actually give up its charter. If that were to take place, it would just become part of the state. If the city gives up its charter, it becomes part of the county.
And that's really, you're asking the court to look at the comprehensive actions by the comptroller and that particular request or option
Right.
that's unique here.
Yes, ma'am. And those instances were more significant, as your Honor pointed out. One owed the IRS, so that was outside debt, federal debt that was there, yet they were not asked to give up the charter. In the other instance, there was $1,000 left in the bank account, and they were not asked to give up this charter. I mean, the town was essentially broke. And so in those two instances, again, the very extraordinary, and we're asking for extraordinary relief today, but let's look at the extraordinary requests of the state. In instances, in those two instances where the issues were not as dire, that town and county were not asked to give up their charters, but Mason was. Understanding the fact, as my able co-counsel pointed out, you have a global project that's on its way. And so the financial issues perhaps were dire with the prison closing, just turned around within the snap of a finger with Blue Oval.
One business goes away, another one's coming, although it's not seamless, obviously.
Absolutely. And I mean, to take a debt to the water sewer fund from 600 down to, more than half, 258,000. I don't think that point should be lost. Not only are you, taking those huge steps to be corrective, that's something that they're willing to do and they met with the comptroller's office to do, and I don't think that's an issue.
Shows a prioritization by your client
Correct.
to take the debt seriously.
Yeah.
But there was also found money, if you will. It was sort of a one-time chunk of money that is not going to be available every fiscal year.
Right. And we understand, and that shows the seriousness of how they have taken this issue. But, this is not without some pain. I mean, they need 2 law enforcement officers. They need other things to protect and make the city better, which they are foregone in order to not have this charter taken, which is the duress that they were under at the time when they were making this decision. And so I heard 60 months of 5 years articulated pretty distinctly at the end of opposing counsel's argument. So that they talk about 60 months, but we're on 27, 26 months. And so, Your Honor, if we were to take full advantage of the 60 months, that would reduce the $258,200 expenditure down to $4,303.33 a month.
Wait, what was that math again?
If you take the $258,200 over 60 months, that would take it down from the the amount now, $9,500 to about half of $4,303.33.
Just a lot easier number to prioritize.
Right, absolutely. And it shows that they're still willing to pay the money, but they're given a little breathing room and they're able to better handle their finances. And again, you're not talking about the 2016 leadership, you're talking about the new leadership. And they're willing to take this, again, as serious as possible. And, I want to be very clear here. So what I was listening for was exactly what I said opposing counsel would do, the ability to approve expenses. And so that is a sore spot for this town. And I want to clarify, reduction of expenses is not a determination of expenses. So opposing counsel touched on the ability to reduce expenses. The statute just said, does not say you can determine expenses, is what they are doing. They are determining what is an important expense and what is not an important expense. They are overstepping the reduction. They're determining what expenses are. And we think that, again, that is a
Feels more like a takeover and less like a partnership.
Yes, ma'am. And I think the statute is clear. And, I get it. Opposing counsel has talked about subject matter jurisdiction, but it may be a standing issue because surely opposing counsel has not stated that an equal protection case cannot be lodged against the state. I'm positive that's not what he's saying. I think what he's saying is a town can't do it, and that probably relates to standing. We're very early on in the litigation, as you already know, and I think when you talk about standing and these kinds of issues, those issues can be corrected during the briefing period or further explained as your Honor is briefed. But we felt the need to come to court because Monday was upon us. Nothing could be worked out with the Comptroller's office, which would be reasonable to allow the city to still be managed and run effectively by the leadership. And so, hence, we are, before your Honor, asking for the extraordinary relief. As has been stated, the first payment of $9,658 has been paid. And so we're good on that. No expense reports have been submitted because that is a point of contention, a big point of contention at this point. But here again, your Honor, the town is serious. They are trying to make it right, and there's no need to be punitive against the city, especially leadership that gets it, and they're trying to correct past transgressions, which they did not cause. Now, again, your Honor, I think it was pointed out that these two elected leaders were on the Alderman's council, but they were not in control. I mean, they had a vote as council, but typically your legislative body ratifies and approves policy, but the day-to-day management of your town is up to the mayor. And so Mayor Gooden was not the mayor, and Vice Mayor Rivers was not the vice mayor. This is new leadership. This is leadership that is committed to making sure that the audits are submitted, that the budget is submitted in a timely fashion, and that they will make all payments to pay back the water sewer fund. If I may consult with co-counsel, I may.
Yes, please.
Three final points as I wrap up here. My co-counsel has been there from the very beginning as the city attorney, and there was no opportunity for Mason to propose his own corrective action. All of these things have been dictated upon him by the Comptroller's office, and it's not been a working relationship. The office of the Comptroller says it's been a pleasant relationship, but I can guarantee you it has not.
I think there's probably two different perspectives on that. Ultimately, they have the big stick of being the state and being able to come in, but I think that the story, at least their representatives tried to tell, was one consultation and collaboration, on whether or not that's how it felt from from the town's perspective, or whether or not that's really how it occurred, I don't know, but.
Yeah, I mean, if the first instance is, I want your charter, I want you to disappear, to me, I don't think that's very friendly or corroborative. And so, and we know that that's a fact that's undisputed here. And it was not addressed by opposing counsel. And the historical aspects and the chart that was put up didn't go to where we are now, and you would have seen a vast uptick in their line because of what's been done to reduce their debt to the water sewer fund. And finally, Your Honor, to say that the Ford Motor project is a once in a lifetime game-changing opportunity, we would minimize it. We're talking about a $6 billion project that's coming right next door to this city. It is really the creation of another city. So as many people will be working in this warehouse and dealing with this warehouse as there are people in Mason right now. And so this is an opportunity of a lifetime for Mason, and so there are grant opportunities. There's a non-competitive grant as part of a $1 billion opportunity for the Blue Oval project that the town of Mason is pursuing. And Your Honor, I'll be honest with you, I feel that 3 calls all the way down, and I'm sure Attorney Clinton as well. There are people, very well-meaning people who are from all over the state that are interested in coming in and retiring this debt and making sure that Mason is put in a way that it can avail itself of this opportunity. So I think that as the time progresses, it will not take 60 months to pay off this debt. I think that it could be paid quicker, but we need the wiggle room in order to not strain the budget of the city to make it happen. And I think that the Office of the Comptroller has overstepped what the statute says it can do. And again, that spot that still is disputed and has not been, I think, sufficiently addressed. I'm sure we'll brief it. Asking the city to reduce expenditures does not mean you can define what expenditures are. And so that and some of the other things that we've discussed as far as the payment, you have 27 months as opposed to 60 months, so on and so forth. Your Honor gets it, and we submit to Your Honor the petition, and we would ask that at this particular point in time, an injunction is warranted, and we would ask that one be granted, Your Honor. Thank you.
Thank you so much. At the party's request, I'm going to give an opportunity for some additional briefing on these legal issues, particularly given the fact that the town has not had a chance to respond in writing to the state's submission, given how quickly this all arose. So I'm going to give the town until noon on Monday to submit additional briefing, and then I'll give the state until 4 o'clock on the next day, which is the 12th, to submit its additional briefing, and then I'll issue a decision before the April 15th holiday, which is a state holiday and a court holiday. So I will work on that decision next week on the 13th and 14th and issue it before that holiday, so that you all have the court's decision on the motion. Is there anything else on anyone's list before we adjourn?
Well, Your Honor, I did want to ask if we submitted a brief earlier, we just give the defendants 24 hours to respond.
So what I would say is the intention is essentially for them to have a little more than 24 hours. Essentially, I gave you all a noon deadline and then before the next day, just because of the because really the court won't be able to pick it up that Tuesday afternoon anyway. If you all submit your brief on Friday, then what I would say is, the state could get their brief to me by 9 o'clock on Tuesday morning. The difficulty is we all have to sort of plan our work. I literally pulled up my calendar so I could figure out what next week looks like for me. So when I had a chunk of time to work on it, and I'm sure you all are having the same thoughts about your schedules. So what I will say is that you all get your brief submitted by the end of this week, then I would say to the state, rather than 4 o'clock on Tuesday, it would be 9 o'clock on Tuesday. You would still have the weekend and that Monday to work on it, but I suspected that Mr. Turner thought he might enjoy the weekend to work on it, which is why he asked for a Monday. So I'll leave it that way. Thank you. And I'll put down an order that reflects that so everyone's clear, and then otherwise I'll rule on the motion after I receive those submissions. I appreciate the arguments in the briefing, and I understand how important this issue is and take it as such. Wish you all a good day.
All right. Court is adjourned.